Hello guys, and welcome to another episode. On today's episode, we'll be talking about the seventh rule, when we are talking about the nature of a confessional statement. Do you understand? In my previous set of classes, I talked about rule 1, rule 2, rule 3, up to the 6th. This particular class will be talking about the seventh rule about the nature of confessions. So at this juncture, let's go straight to my notes. Now, when you are talking about the seventh rule regarding the nature of a confessional statement basically tells us how exactly you can challenge a confessional statement when the prosecution is about to adduce that confessional statement into evidence. Do you understand that? Now, the first thing is where the accused alleges that the statement is not his own and denies authorship of the statement. While the second thing is where he admits authorship but states that he did not voluntarily make this statement. Now, in the former situation of denying authorship, that is the first one, the statement will still be admissible, but the court will decide on the weight to attach to it. The authorities are AKPAN versus the state and OVIE versus the state. The fact that the accused has denied making the confession does not necessarily make it inadmissible, as we can see also in the case of R versus John AGARIGA-ITULE. R versus John AGARIGA-ITULE. In this case, the fact is that soon after the appellant was arrested for murder, he made a statement to the police in which he admitted killing the deceased but described circumstances which, if true, would amount to a legal provocation. The next day, he denied having made the statement and made a new one in which he repudiated all the responsibility for the deceased's death. The court held a confession does not become inadmissible merely because the accused denies having made it. And in those respects, a confession contained in a statement made to the police by a person under arrest is not to be treated differently from any other confession. In the latter situation, that is the situation where he admits that he wrote it but that he did not write it voluntarily, then the court is to conduct a trial within trial to determine the reliability or otherwise of the statement. Where the statement is not shown to be reliable, the court must hold that it is inadmissible. Where the objection to the admissibility of the accused person's statement is merely that it was not read over to him or that he did not make it, then the statement is not rendered inadmissible. The inadmissibility of a statement becomes an issue for trial only if the allegation is that he was coerced or induced to make the statement, as held in the case of OVIE versus the state. Failure to conduct a trial within trial in a case where the admissibility of a statement on ground of reliability is challenged renders the confession inadmissible, as stated in the case of OBIZODO versus the state. In a trial within trial, the burden of proving reliability of the confessional statement is on the prosecution. So yes, as we have seen so far, we have two grounds for which you can challenge a confessional statement. The first one is when you say, oh, I am not the one that made this confessional statement. I was not the one that wrote it. Do you understand? In that first instance, what is going to happen? In the second instance, we are talking about where you wrote it, but you said you did not write it voluntarily. You were being coerced to write it, or some other factors, came into play, and that was the reason why you wrote it. Now, in the first instance, where you said, oh, you were not the person who wrote it, in that case, the confessional statement is admissible. However, the court is to determine the weight in which it will attach to it. There's a difference between when you deny authorship and when you admit authorship and said that the circumstances under which you wrote that particular confessional statement is such that wasn't voluntary or such that was coerced. Do you understand that? Now, where you are objecting to the admissibility of a confessional statement tendered by the prosecution in a particular case, then you are also telling the court that immediately there must be a trial within trial to be conducted. Do you understand that? Now, what is a trial within trial? Now, when you are having a trial in itself, like someone has killed somebody, or someone has stolen something, or someone has 1,000 other crime, whatever it is. Now, where you get to the point where you are bringing the IPO to the stand, you know, you have to call your witnesses. Now, you are calling your witnesses. You've called the IPO to the stand. The IPO is currently on the stand. You are asking the IPO question. That's the prosecution. Prosecution is asking the IPO question. So, Mr. IPO or Madam IPO, how do you get in contact with this case? The IPO will say, oh, on so day I was called and this and this and this happened, and then when I was called I went to the crime scene and then we investigated, and after investigating 3 days later we went to arrest the accused in this case. Can you kindly point to the accused? That is the accused. Very well, that's the person that we arrested. Okay, so when you arrested him, what happened? We brought him for questioning at the station, and then when we got to the station, you know, he was confessing as to what exactly happened and all that. And it was at that point that we said, okay, let us bring a piece of paper, or you know, a paper for him to write down his confession. And then he was writing down his confession and all that. After writing down the confession, he signed, and I also signed as the investigative police officer for this particular case. Do you see that? Now, at that point, he has not done anything yet. Oh, just wait. The prosecution immediately will want to tender that particular piece of paper, the confessional statement, into evidence. So the prosecution will say, if you see this particular confessional statement, would you recognize it? He will say yes. Then they will go and bring the confessional statement. Then they will ask him, how would you recognize this confessional statement? He has my signature under, is dated 15th of blah blah blah, he has this, he has that, in order to be able to show that he recognizes the confessional statement. Now they will give the confessional statement to him and he say, yes, this is the confessional statement. Then at the point where the prosecution then says, my lord, counsel seeks to tender this confessional statement into evidence. That is the point. As a defense lawyer, you are supposed to stand up to object to the admissibility of the confessional statement. Why? Because if you don't object at that point, that confessional statement is definitely going in. And then when it goes in without your objection, it is deemed that the confessional statement is true. Do you understand that? So therefore, you have to object immediately. Now, when you stand up to object, if you stand up to object to the authorship of the confessional statement, like I have said earlier, it is going to enter regardless. The court will just be the one to determine the weight in which it will attach to it. But if you are objecting to the confessional statement based on the fact that yes, your client had written it, that's the accused, but he wrote it under circumstances that were not voluntary, then immediately you have to quote section 29 of the Evidence Act to the court. When quoting section 29, you also have to tell the court that since the confessional statement was taken under grounds that are alleged to be involuntary, then there should be a trial within trial immediately. Now, when you do that, what the court will do is that the court will stand down the case that is currently going on, and then the court will start a new case. That's a new trial. And that trial, the only aim of the trial is to test the voluntariness or the reliability of that confessional statement. Do you understand? So then the IPO will begin to testify as to how the confessional statement was gotten. You, as the defense lawyer, while listening to the IPO, would note certain things and then ready your cross-examination to cross the IPO as to how exactly he got the confessional statement. And not just that, also at that point, you are not opening your case. Don't forget that it's another trial. You are going to bring the accused and any other witness that can attest to the fact that that confessional statement was not gotten voluntarily. Either the mother that will come and show that he came to give him food, severally they turned down the food and he did not eat when he made the confessional statement, or somebody who was at the police station when they saw them torturing him, or something that can prove that that confessional statement was not gotten voluntarily. So you either bring the accused to testify, you should bring the accused to testify, and not just that, also bring somebody around that can show that that confessional statement wasn't taken voluntarily. Because by the time you are able to prove that, the court would then rule on the admissibility of the confessional statement and tell you whether or not its judgment is to admit it or to reject it. it. But at that point, the court must rule as to the admissibility of the confessional statement. And when the court rules, you can appeal if you don't like the ruling of the court. If you don't like the ruling of the court, you can appeal that that particular confessional statement should be expunged from evidence. And don't forget that the burden of proving that that particular confessional statement is voluntary and reliable is on the prosecution, not on the defense. Although the defense is the one alleging that it wasn't gotten under reliable circumstances or voluntary circumstances. But then, although the principle of law is that he who alleges must prove, but in this case, this is one of the rare exceptions to that principle, because although the defense is alleging that, you know, the thing wasn't gotten under, you know, reliable or voluntary circumstances, the prosecution is still the one that has the burden of proving that it was gotten under reliable circumstances beyond reasonable doubt. Do you understand? And where there has been an objection on the admissibility of a confessional statement and a trial within trial was not conducted, automatically that confessional statement, even where admitted on appeal, can be expunged, because there has to be a trial within trial where there is an objection to the admissibility of a particular statement based on the fact that the confessional statement, though written by the accused, was not gotten voluntarily, and therefore the reliability of the confessional statement is being called into question. Do you understand? That is that for the nature of confessional statement. In my next lecture, I will start with requirement 1 that we are supposed to have when you want to admit a confessional statement. There are about 4 things that are supposed to be complete when you're about to admit a confessional statement. And our first lecture on the requirement when admitting a confessional statement will be my next lecture. So I will see you in my next lecture.